I won't name names, but there's definitely people who are associated with this who just, crank possibly hundreds of these out every single day just because it's all templated. So it seems almost malicious at this point, unfortunately. So the California Invasion of Privacy Act, or CIPA for short, is a privacy law that was enacted in 1967. And basically what it was meant to do, it was meant to stop eavesdropping on landline phone calls when one of the parties to the phone call is a resident of California. And basically that came from Cold War paranoia that people were listening to landline phone calls. So what happened is that these opportunistic lawyers filed a bunch of lawsuits alleging that resident of California using a website is a communication between the website and the resident of California. So the law was never meant to apply to websites because at that time that wasn't even a thing really. But, these opportunistic lawyers, they saw that this lawsuit allows a private right of action, meaning that it allows an individual to sue someone else directly. So it's not enforced by like attorney generals or data protection authorities like other states or countries' privacy laws are. So they saw a great opportunity there in the sense that they could sue website owners for quote unquote intercepting communications with a resident of California between that resident and the website. And what does that mean? That means things like, Google Analytics or Facebook Pixel or even chatbots. There's a communication between an individual and the website. So like I'm clicking on this page or I'm submitting a contact form or I'm interacting with a chatbot, but there's a third party like Google, Meta, or the chatbot provider that's in the middle of that communication, intercepting it. At least that's the argument. So when these CIPA lawsuits first started with websites, it was only targeting websites that collect really sensitive personal information like healthcare information, financial information, information of children, and things like that. But over time, these lawsuits have evolved from targeting those types of companies and from targeting like really large businesses to targeting really small businesses where there's no sensitive personal information involved whatsoever. So for example, you might have a really small business selling widgets online where there's no healthcare information, anything like that being intercepted, but the lawsuits have been targeting those businesses as well. So it's started large businesses, really sensitive information, and now it's really any business of any size collecting any kind of information through these trackers. Sure. So what initially happens is the website owner would receive a demand letter saying that an individual from California was tracked without their consent, usually has screenshots of these trackers being applied to the user's device without their consent. And it asks the business owner for money, or it says that, we're going to file a lawsuit. And it could be, anywhere from $10,000 to $100,000 to sometimes it's $50,000. But usually it's enough money to be really concerning to the business owner, especially when it comes to small businesses. They don't just have a spare $50,000 lying around. And what these demand letters say is you have X number of days to respond. If you don't respond or you don't pay, we're going to file a lawsuit against you. I've seen some of these demand letters and they say things like, defendant is operating a surveillance network. Almost like these small business websites that have analytics on them are conducting some kind of CIA level surveillance, even though we all know that's not true. But they allege that the person visiting the website was extremely offended, injured by the surveillance network that the website owner is running, just really laying it on very, very thick. But, for business owners, that's obviously really scary. And if you have gotten one of those letters, you definitely should speak to an attorney about how to handle it, because there can be ways to handle it where the person filing the demand letter goes away, or there's a way to settle it for like a smaller sum than what they were asking for. So definitely make sure you speak to an attorney about that. very easy to tell if the website is tracking you without your consent. You can test this out yourself. You go to the website in an incognito window, you open up your applications tab, and then you see what cookies are firing before you consent. Yeah, so you got to understand that, from the plaintiff side, these letters are extremely lucrative. Essentially, what we've seen is that they have one template for these letters, and then they change the website URL, the business name, and then add new screenshots, and everything else is literally the same because you can tell between one demand letter and another, they use the same exact text. So initially, this was filed by lawyers who were experienced in privacy, right? So it started off that way. Now we're seeing all kinds of lawyers file these letters. So we're seeing, lawyers that used to work in personal injury, lawyers who used to work in contracts. Everybody under the sun is trying to cash in on this because it is so lucrative, because it's very easy, right? You just take some screenshots, put them in your template, and then you're done. So we're seeing a lot of lawyers get in on this. What's unfortunate too is that we're seeing a lot of the same plaintiffs. So a lot of these law firms, what they have is they have 5 plaintiffs in California, and they tell them, go to this website and see if you're tracked. And then they're tracked, and then boom, there's a demand letter. I won't name names, but there's definitely people who are associated with this who just, crank possibly hundreds of these out every single day just because it's all templated. So it seems almost malicious at this point, unfortunately. So basically what it needs to be is that a visitor from California visits your site. So it doesn't matter where your business is located. So your business could be in Illinois, it could be in Georgia, it could be in Alabama. That part doesn't matter. If somebody from California visits your site and they're tracked without their consent, that's when CIPA applies. Sure. So the first thing that I would do if I was a business owner is I would review all of these trackers on my website and see whether or not they're actually necessary. So because of CIPA, these trackers are actually really high risk tools for your business now. So let's say you had Facebook Pixel on your site, you ran your advertising campaign, you're not running any ads now, and you don't plan on doing so in the near future. Remove it. Same thing with like Google Analytics or Hotjar. If you're not actually accessing this data and you're not doing anything with this data, remove it from your site altogether, because the risk is just really not worth it if you're not using those tools. So the first step is removing those tools from your site if you don't need them, making sure you do actually need them, or you could replace them with privacy-friendly alternatives. So for example, from Google Analytics, you could go to Fathom Analytics or Matomo Analytics that don't track people as much. Then, once you've done that review, if there are some trackers that you still do legitimately need for your business, you would want to make sure that you obtain consent before placing those trackers on the user's device. So what you should do is obtain a consent solution, that little pop-up that asks people if they want to agree. You want to make sure that it stops those services from firing until the user provides their consent, and also that they can opt out. And then obviously test it, make sure it's working the way you want it to work, and then put that on your website to make sure that you get the proper consent.